Manever I say ma PENDREAM TV. PENDREAM TV there, I see them yopo.
Now, you are once again welcome to PENDREAM TV, the only channel that brings you the best and latest updates in politics. If you are new here, please don't forget to subscribe to the channel, hit the notification bell for more updates. Like and also share to other members to watch as well. You can equally leave a comment after watching or send us a voice note on our WhatsApp number, which is 0277 128 777. Thank you. Still on the matters of the Supreme Court ruling, which Gyampo has also come out to react to, is saying that the NPP is a party he side with the opposition, but they are sometimes annoying, and they have to admit that Michael Oquaye has also heard and apologized to the people they offended, because what they did may create a lot of problem in the future, which they are not seeing that side. With that much I do, I would like you to join me listen to what he said into detail. Thank you.
I'm wondering whether I have anything useful to add. I think he's been fantastic in his delivery on this matter. He's a man that I have a lot of respect for. He cares about institutions and how institutions will have to function well to bring about good governance. And so I don't know what I have to say. In addition, he said all the issues, yes, there are serious issues with regards to the jurisdiction of the Supreme Court in this matter. And then he's telling me and all of us that if that matter is not settled, then everything else that happens, afterwards, it's null and void. And so he's also raised issues with, there's another issue with an attempt to order, Parliament as to how it goes about its activities. There is an issue also raised with respect to the mode of appointing justices of the Supreme Court. Mm-hmm. And then he put it aptly that you cannot say that an institution should be independent and that its heads should be for you. It doesn't make sense. And if we have people with the mindset of statesmen and women running this country, they would endeavor to question and interrogate some of these things and change them. But it appears that all those people that we've so far had as leaders, many of them haven't had the mindset of statesmen and stateswomen. And so they have oftentimes pandered to the weaknesses of the system and also exploited the weaknesses of the system, to their advantage. You're talking about empaneling of judges, to sit on matters like this. A matter like this that has created a serious constitutional crisis, and you are asking for judges, you are looking for judges to sit on a matter, and you don't bring the experience once, and you are told that the Chief Justice has a constitutional mandate and he has the power to empanel
and viewers cannot hear you clearly. Make your point.
Okay, so as for President Akufo-Addo, I've said I'm not going to talk about him again. It's checked out, so I'm not talking about him again. If you talk about
for example,
we talk about him continuously. It's checked out and it amounts to romancing a stone. I'm not interested in romancing a stone. But so we're talking about empaneling of justices, judges to sit on such important cases. And we are being told that, the constitutional right of the Chief Justice to be empaneling, and so she can decide whoever she wants to sit on a case and all that. You see, rigid application and following of such constitutional requirements ushers people into a regime of robots. We should be able to think about the consequences, of our actions, especially when handling matters like this. Otherwise, then the trust, the public trust and confidence in the Supreme Court would continue to be decimated. And I am surprised and a bit worried that, as I've indicated earlier, the Supreme Court itself doesn't seem to be doesn't seem to be interested in how it is perceived, out there. Otherwise, in such an important matter that is creating a constitutional crisis, you would have looked for people. There are certain people who, when they preside over some of these cases, even if you don't agree with them, you would see wisdom in their pronouncement, in the way and manner they go about things, by virtue of the fact that they are experienced, they are more learned, they are more, they've been there for long. Okay, but if you bring people whose decision we can easily predict, and given what they have done in the past, then it becomes a bit problematic. So these are some of the preliminary issues that have been raised earlier, and I agree with them. But you see, the substantive matter that I wanted to address, it appears that Justice Atuguba is saying that if the matter about jurisdiction is not settled, then all other things that come up, becomes invalidated and all that. So yes, if indeed the Supreme Court didn't have the jurisdiction in this particular matter, was it that they were thinking that the High Courts wouldn't have done a good job, or what? I mean, so why the haste in going to usurp the powers of the lower courts? I think that they should have allowed the lower courts to handle this matter. And more importantly, Alfred, you've heard me say severally that, you see, in this particular matter, the courts, in my view, were in the place to resolve the matter. I heard some judge saying that Parliament has its own standing orders as to how some of these things could have been addressed, and this would have brought about some peace. See, they're going to court and looking for adversarial means to address some of these matters will yield a certain benefit. But I can tell you that it rather has opened the gates for more problems in our governance system to be unearthed. Because yes, you may have won, you may have gotten the Supreme Court to decide in a particular way for you, predictably. But what are you going to do? Parliament is still not functioning, and government business must run. How are you going to ensure that the rest of government business go on? And I was expecting that there will be discerning people, there will be matured people, there will be sober-minded people who would have thought about all these things before quickly rushing to the courts and asking them that they should use their adversarial processes to address this particular matter. And well, we live to see. But I'm saying that those who are celebrating that they've gotten the cause to decide in a particular way, they have not won anything. Because now the real deal is going to be how Parliament is going to be responding. How about if they decide, the minority side decide that, well, we are also not going to be part of processes. How are you going to achieve that quorum to be able to make important decisions? And so I am a bit worried that we, in our quest to upset the balance of power that is expected to exist between the arms of government, have now created more problems, for ourselves and for our democracy. And I think that, look, if there are level-headed people in this country, and if leadership of political parties would be matured enough, we are not looking for youthful exuberance. We are looking for leadership. I've always said that, look, in the aftermath of the 2008 elections, I know leaders who led the processes behind the scenes to ensure the transfer of power from the outgoing government to the newly elected government. And I'm expecting such caliber of people to be at the forefront of leadership when it comes to Parliament. Okay, I think that there is too much boisterousness being shown on the floor of Parliament and in navigating these processes. It doesn't help. So that's why we are here. We are where we are. And then I also want to make the point that, you see, Alfred, you have listened to me right from the beginning of this matter up till now. Indeed. My position actually is in sync with the NPP's position. And I don't mind, espousing it again. My position is in sync with their position. It's just that because of their practice of unprincipled politics, sometimes they are annoying. You must first of all admit that Michael Oquaye goofed. When Oquaye erred in giving that judgment, and when it was in favor, you liked it. Why didn't you take it to court? And so you should first of all come out clearly to say that Ghanaians, when we did that under Michael Oquaye, it was wrong, and we are apologizing. And in this particular matter too, we think that the speaker, and then you can be building a certain consensus. You can be showing a certain principle. You can be telling all of us that you believe in what is right. You are doing principled politics. But during Oquaye's time when he was wrong, you were happy and excited about that. The President Akufo-Addo himself was going about saying that he was not going to be working with a Siama. Okay, you liked it. Now another speaker does it, and then you take him to court, and you want us to all of a sudden pretend that we've forgotten what happened, in the past. And if you do that, you see, then you are annoying. And when Asifua was talking, I was expecting him. Like I said, I believe that a declaration of an intention to contest a future election should not invalidate one's membership of parliament and one's representative role in a current parliament. And if you recall, I gave the historical antecedent to it. You now are studying, or you just completed law. But before law, you've studied law, you are a lawyer. But you see, lawyers should know that every law that is passed would have something that made the law to be passed. And that was how come the last time I went through the historical antecedents of this particular law that seeks to deal with cross-carpeting. I told you that long ago in 1958, Kwame Nkrumah had passed the Notorious Preventive Detention Act of 1958. And that act of parliament was simply to say that if you are a suspected political enemy of the regime, the law enables Kwame Nkrumah to throw you into jail for 5 years. You go into Nsawam and then come before your matter will be heard. And through this law, he was terrorizing so many political opponents. RR, Amponsa, and Co. He was terrorizing all of them. And through this law, people of the NPP, Northern People's Party, J. Brahma, and Co., some of them, they had some of them, their pastors, some of them, their relatives, some of them, their well-wishers had to go and plead with them that given how Nkrumah is handling you, you must simply cross-carpet to be able to get your peace of mind. And through that, Nkrumah using that intimidatory tactics, got some of these people who were opposed to him to cross-carpet to support the CPP. And so the cross-carpeting took place in that parliament of the CPP, and it was through that Nkrumah got the majority of votes to be able to pass the Republican 1960 Republican promulgates that 1960 Republican Constitution. Okay, so the point is this: if you are in parliament today, your decision should to cross-carpet. If you take it today, and so you are. I mean, we all know what were you saying when you were talking, because you are annoying. I couldn't supply you with that information. But you can bring Wayoseni's example. Wayoseni was a member of parliament, and in that same parliament, he moved to another political party, and then he signaled the speaker. His seat was declared vacant, and then an election. So the decision to take a certain. The decision to contest for a position, okay, on another party's ticket in a future election, it does not take note of this. The idea of cross-carpeting is to reduce the numbers of your opponents in parliament. Okay, so when Nkrumah encouraged or intimidated people to cross-carpet, he reduced, by 1960, he had reduced the NPP's, Northern People's Party's numbers significantly. Okay, but this idea that we are talking about, the issue that is currently confronting us, it is not reducing the MPP's numbers in Parliament.
Yes.
They still have one. Is it 136 or 137?
137.
136.
No.
No. They use it to sack Alan and Co. It's because now they see they are hot.
And that is why I'm saying that the lack of principled politics.
No.
I've received
Alan Chemanting and Bobia Samoa. No, it's the same principle. It's the same provision that you use.
Now he's said. Hold on.
So now I apologize to them. I apologize to them.
Sam, this is law. Sam, this is law.
I apologize to
a member of the
Hold on,
but he's not the member of party. He was not the member of
hold
party.
on. He's answered that question.
So,
I mean,
rightly so. If and it is true, if a party's constitution is subservient to a national constitution, then the MPP owe medicine man Hoops in Adoye. I call him medicine man. No, he didn't to Hoops in Adoye, Alan Chemanting, Mbwabia Samoa. You owe them an apology and great compensation because, well, I mean, you may disagree, but the point is this. If you say that they have automatically forfeited, okay, their membership of your party by virtue of the fact that they moved to another party, and today you are also offering a certain defense that goes contrary to the position of your party's constitution, then I think, in all fairness, if you are doing principled politics, you see, our challenge is that we lack principles when it comes to our politics. So what we did yesterday that was wrong, and we supported today, if we want to vary it, then we look at other reasoning, and it doesn't help. So my position is simple. Yes, I agree with the issues that have been raised with the jurisdiction of the Supreme Court in this matter.
Right.
But my position is that if somebody takes a decision today that in 10 years' time I will contest an election on another party's ticket, it should not invalidate the person's membership, of Parliament today. And when I'm saying say absolutely, when it's agreeing with you, say absolutely. But when we disagree to you, you are calling me names.
So you see, Prof, this, Prof,
I'm saying you generically.
For example, this matter obviously wouldn't have become an issue based on the stance that you espouse if the MPP itself didn't have this provision in their constitution, which Mr. Sefwa says now that it is unconstitutional, and in fact they would have to even amend their constitution if the implication of the Supreme Court ruling is anything to go by, because it renders that provision on the forfeiture of the membership null and void of no effect because of the consequence of this particular ruling.
Well, it's okay. I mean, constitutions, there are the 1992 constitution says that if your law is in contravention with what the parent constitution, mother law of the country is, then we have to set yours aside. So he admitted, but see, he didn't have the courage and boldness to say that, look, maybe then our constitution, we should just set aside that provision. But the point is this: your constitution is your constitution. If the mother constitution of the country that is supposed to be upheld and is superior to your constitution says something otherwise, or different from your constitution, then we have to uphold what is in the national constitution. And you should be bold, sincere, and candid in admitting some of these things. But you see, like I said, we don't have principles in the conduct of our politics. So the very things that we said was good yesterday, today, if it is being done to us, we say it's not good. And rather than resorting to very conciliatory and a matured way of handling matters, we run to Supreme Court. And why do we run to Supreme Court? Because we know those who are there. You see, it is normal. Let me tell you, in advanced, because we know those who are there. In advanced democracies, Trump is in. He would appoint, people of that who believe in his ideology. People who see eye to eye with him. If there is a vacant position in the U.S. Supreme Court, he would appoint people he believes in, there. People who see eye to eye. So for me, it is not too much of a big deal that, look, Martin tomorrow if I become a president and we share the same ideas on some issues, and I'm appointing a chief justice. But Martin, I know you agree with me, and so then I'll take you there. But you see, in those jurisdictions, the people who though may be in agreement with the appointing authority in terms of ideological persuasions, will still have the courage to look into the appointing authority's face and say, though ideologically we agree, but this one we think you are wrong. But in our part of the world, we appoint people who are expected to be ad idem with us in terms of ideological persuasion. And these people are not able to assert themselves to say that, yes, even though you appointed me and I agree ideologically with you, this one you are wrong. They are not able to say that. And so they are always thankful to the appointing authorities in everything that they do. They are always behoving to the appointing authorities on everything that they do. And that's how come, in my view, in developing democracies, when we are appointing people into such higher positions of public trust, we should look at people who, apart from the fact that they may be agree with us, they would have the courage, the fortitude, the strength, and the ability to look into the faces of the appointing authorities and tell them, this one you are wrong, this one we don't agree with you. It's becoming one too many. When people are appointed, they are always behaving, they are always looking up to the appointing authority, even when they know that the appointing authority cannot even sack them. What is wrong with us?
But Prof, you see, and staying on this matter, because let me conclude with Prof, because I'm still dwelling on the governance matter and then also the legal issues that you have dealt with. To the extent, because you make reference to the historical antecedents leading to this, the context and the mindset of the framers of the Constitution in putting Article 97 there was meant to check a situation.
Yeah.
And the Constitution, be a living document, obviously will go through some of these reforms. But for instance, in 1979, which I know there's Popular Front Party, Victor Usu's party, led the opposition in parliament against Ehela Liman at the time. Two principal members of Victor Usu's party, lawyer Kwekuba and also J.H. Owusu Gyampo, if you recall, entered parliament on his party's ticket. But eventually, they later declared that they were no longer part of his party. Yet they remained in that parliament. They continued to do so until the 1981 coup. So the framers of the Constitution, having this and mindful of the events of 1979, Article 97(1)G and H maybe were introduced to address and prevent such mischief, is it not?
Well, I think, you see, if somebody violates or run afoul of a constitutional provision, we'll have to make sure that the rule is implemented. What the 1979 issue that you are referring to was a clear violation of the Constitution, and somebody should have taken the matter up. And you see, one of the challenges of developing democracies is that rules are not implemented. Even when people run afoul of the rules, sometimes we look at those who may have broken the rules and then we decide to let it slide. So the point is that what happened in 1979 was not good, and you do not expect that and that's how come what happened in during the time of Wayoseni was also was addressed. Okay, Wayoseni got to parliament on the ticket of a political party, and then within that same parliament, he said that I'm no longer a member of this party, and that was how an action was taken to make sure that a by-election was held. Okay, to address that situation. So my view on this matter, fortunately or unfortunately, agrees. And I speak based on conviction. I don't care about if it agrees or disagrees with anybody, but purely based on what I've researched and what I know, the reason why the idea of putting in place legislation to deal with cross-carpeting was to ensure that whilst you are in parliament, you don't move to another party within that same parliament. It was never aimed at addressing a future ambition or intention. Me and Kweku Azar, we agree on this. And so, right from the word go, I knew that the Supreme Court was going to rule in a manner that is in sync with my position. But the challenge I have with the Supreme Court is that, you see, the predictability. Let me say, if we talk about strengthening institutions of state, we simply say that there must always be rules to regulate how things are done. Number two, the rules of the game must always be well known. Number three, the rules must be enforced. Number four, the rules must be internalized. Number five, the rules must be predictable. Okay, if you say the rules must be predictable, what we are saying is that we should be able to predict what would happen to you when you run afoul of the rule. That's what we mean by the rules should be predictable. Now, in talking about the rules being predictable and then in talking about the rules being predictable in relation to the functioning of the Supreme Court, yes, it is good that we are able to predict the Supreme Court, but the way a manner will we predict the Supreme Court must be in the area that we can always be predictive with some certainty that the Supreme Court would rule purely based on competence. The Supreme Court will rule and it will not throw consistency to the dogs. The Supreme Court will rule and then the judgment will be seen as fair even if we disagree. But it appears that now we can predict the Supreme Court that look, they will rule in a certain way and then they will do so in a manner that is pushed or driven by partisan politics, and it is not the best. So people can predict. Oh, as for these people, now that the matter is going there, by virtue of sheer partisan politics, we can predict that they would go this line, and that is not the kind of predictability we are talking about when we are talking about when we argue for the central argument of the institutional school of thought that says that rules should be predictable. Okay. It shouldn't be like that. We should only be able to predict that, look, the Supreme Court would act fairly. We should be able to predict that the Supreme Court would act in a manner that is consistent with its earlier position. Okay, you are saying that we should not under any circumstance entertain any move that would ensure that people are not represented. You are saying it. And the justice we are talking about was articulating this brazenly. And I'm saying that you are inconsistent and you are not principled because you know that others have not been given representation for close to 4 years. And you ruled in a manner, in this question matter, you ruled in a manner that denied momentarily, temporarily representation of some people. And yet you are espousing principles and judgment that goes contrary to that thing that the courts had done previously. And so you are not consistent. Okay. And it is worrying. And so I agree with many of the things that Justice Atuba, said. And it's important that we staff the courts with people who have statesmen and stateswomen mentality.
Thank you for staying to PENDREAM TV. Really appreciate your time. Please, if you have not yet subscribed as a new member, please, I'll urge you to do so in order not to lose or mix out what is happening around the political arena. Thank you. Stay tuned for more.
Dedi kama amena PENDREAM TV ase. Na so far so good. Say open online portal e wo Ghana. Ah nipa share, nipa follow, nipa comment here. To my best of knowledge, without any biases, PENDREAM TV.